other police people, personnel, that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from the transcript of it. The defendant is confronted with, as he said, and the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's...
You can win one of these for free. Just stay to the end, my friend. Hey, bruh, if my lawyer came in looking like that, y'all know how that dude from New York be like, pack him up, bruh. Pack Buddy up. My man came through shirt, but I'm surprised he ain't had taco meat, brother. But hey, let's get into it, because today I think YNW Bortlen was sitting there going, sitting there looking at my lawyer, saying down to myself, you smell like a fifth of Henny. I should have picked somebody else.
Answer yes or no. Yes. Okay. At some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6. 5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving and speaking to you? You were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
The text on top of
And describe to me the room that you were in. Was it were you there by yourself or other people in the room?
It was like a private hospital room. Probably maybe 4 different officers in the room. They had some outside the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
One of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing in the room.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yes.
And at any time were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave?
No.
What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They're gonna let you go.
Prior to you giving your statement to the officer, the detectives, at some point were the handcuffs taken off?
Yes.
Why?
They wanted me to go take, they wanted me to go take something.
The urine set? Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you out, one of the officers?
One of the officers, one of the deputies that was stand guard in the room, they walked me out and walked me into a separate restroom outside.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room?
Yes.
And then at some point, there are 2 detectives that come in, right?
Yes.
At any time during your interaction with those detectives, did they tell you to agree to leave? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence. They're collected in evidence.
It's not as you cancer. No, I'm not aware.
You say you were handcuffed. How long were you handcuffed for?
Most of the time I'm there. And the room was in the hospital.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until I'm there.
You say twice in
Until he said I can leave.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? going to show you what's being marked as states for evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? Just find out who states B and evidence of states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be in evidence. That's State's Exhibit 2, only for the purposes of this hearing.
Going for motions to suppress. That's what you're getting right here in this clip, is that we're trying to suppress this. That's from YNW Bortlen side. The state is trying to admit this in what they're talking about, because apparently there's arguments over his statements that basically was given. So we'll see how that continues on. Let's go.
Mr. Henry, you agreed to ride with Detective Toyota after the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday,
Yes.
out where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Whichever objections outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir. You can answer the question.
You did not ride with Detective Toyota? You were in the back seat. Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home? No further questions.
All right, based on that, any redirect?
Judge, just briefly on the photo.
Yeah, please go ahead.
Mr. Henry, this photo that you were shown of you in the hospital, do you recall pictures being taken of you?
That moment.
You do recall the officers taking photos of you? Was this taken before or after the handcuffs were taken?
Objection, Your Honor, said it doesn't recall the specific.
Hold on. Over the state's objection. Go ahead, sir. What's your answer to that question?
You said you recall some photos being taken of you. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After. No further questions.
Based on that, any recross? Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friend came to pick me up.
Someone came and picked you up from the hospital?
Yes, sir.
And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th. That's what happened.
All right, State, based on my questions, do you have any additional questions?
No,
Defense, based on my questions, do you have any additional questions?
No, no.
Okay. Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Okay. So it's just argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress, and I assume you want to suppress, well, I heard, which I think is contained on State's Exhibit 1, for this hearing, there's two statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything? Okay, go ahead, sir.
He was not Mirandized, as we know. I think the state will stipulate for that. But what the issue is obviously, he was not at the police station. The issue of whether he was in a situation where he should have been Mirandized. Whether the interrogation, as it were, constitutes an interrogation, whether or not it's custodial. Now, the defendant, the police had a shooting. We heard the testimony that a car arrived at the hospital with two bodies in it. Mr. Henry was driving the car. Two bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that was there that there was a drive-by shooting, and he explained to them where it happened. We know from what the detectives testified, other police people, personnel, that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from the transcript of it. The defendant is confronted with, as he said, and the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm going to call it a custodial situation when we get to that point. But at any rate, the statement was, the defendant is confronted with Bertrand and Moretti. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name's Detective Bertrand, and this is Detective Mark Moretti. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding, you told these officers something, but the evidence doesn't show that happened right here.
Now, even though we have certain things that exist and certain theatrics from certain lawyers, and I don't want to say theatrics, just better memory, that does not mean that the lawyer is bad, bro. Like, I've personally worked for a lawyer, and he used to do the same thing. And he's one of the most popular lawyers in Jackson, Mississippi, you know? So I don't want to sit up here and say, hey, bruh, nah. And if y'all want to know who the lawyer is, I think he don't mind me giving a shout out. Shout out my guy, Tony Baldwin, Toney Baldwin. You owe me some money now, homie. But yeah, so, you know, it's not a bad thing. I know people are looking like, bruh, you don't even know what you're talking about. Yeah, you kind of got to stay on point when you start citing case law and all that. A lot of people, and you've seen it in a bunch of trials, they start referring to iPads and computers and all that. He doesn't have that. Some lawyers like to do it that way. So it's not a bad thing. But let's go on.
That's confronting the defendant with something that's complying. He already said he committed a crime there. He was lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Mirandized, because the rest of the statement is what they're using to formulate the rest of the case. And I would submit to the court that the police had a duty to Mirandize him under that situation. They formulated, they have a crime, there's no question a crime committed, occurred. They called it a crime scene. The scene at the hospital was taped off. It was at the crime scene. Half of the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people, he said there were 4 in the room with him. The detectives corroborated there were a bunch of policemen with around him. Was there a duty to Mirandize him? I submit to the court that in this situation, the defendant was, well, according from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation, as this court, as the Supreme Court, as this court has explained. A person is in custody if a reasonable person placed in the same situation to his or her freedom of action was curtailed to a degree associated with the act of arrest. The proper inquiry is not the unarticulated plan of the police, but how a reasonable person in the suspect's position would have perceived the situation. Would a reasonable person in the situation of Mr. Henry have felt like he was not free to leave? Would he have felt like he was under arrest? The answer is obviously yes. He's there, a crime occurred. He's in a situation where the police are telling him they don't believe what he said happened. They made it clear that they think he's lying to the police. How would a reasonable person perceive the situation? You're in a hospital bed, you have policemen all around you, you're being accused of lying to the police. Would a person perceive the situation as one where they're free to leave? I submit to the court on the totality of circumstances, they would not. I concede the cases state that a hospital is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect perceives. Any reasonable person, it's a reasonable man's hand, as to whether a person would reasonably believe they were in a situation.
I'm sorry. I apologize. Just pause 1 second. This is Mark.
I mean, everybody does that. Everybody cites case law. So then you're going to have the state go back and forth, and we'll just leave it right there because I think y'all can pretty much see exactly where this is going. I thought personally that the judge would be more favorable towards one side. So let's see if my predictions possibly could have came true. But that don't mean you can skirt the law. So, you know, it is what it is.
In my mind, I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So, again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of some Miranda rights, and where I do find that this was in fact interrogation, I do find, based on everything that I've put on the record, that Mr. Henry was not in custody. Therefore, respectfully, the defense motion to suppress both the statements is going to be denied. I'll enter a written order that reflects such,
If and when we arrive at the part of the trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously made. So I'll enter a written order as to that. Next, state, you filed a state unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one. And number two, the motion in limine is otherwise moot because they don't intend on calling Michelle Boutros or Christine Bradley as witnesses. State, is that correct?
I believe that's still correct.
Defense, is that correct? Okay.
The way it stands, I don't believe we would.
All right, so.
And should that happen, we can address it.
Okay, well, as far as the motion for relief just to file your motion, that's granted, and I'll enter a written order as to that.
So let's understand something. YNW Melly and YNW Bortlen cases are different. And what they were saying, meaning the people, what they were saying is that essentially, bruh, he might beat it because the case might be weak. I don't believe that. I believe that if YNW Melly is guilty, then Bortlen was going to be found guilty ultimately, and he was going to get offered a substantial amount of time reduced, but he was still going to do time. What it looks like they're saying is this. He basically going to jail because he didn't snitch on YNW Melly. That's how it's coming off to me. It's looking like he about to get time. This is how they're putting it out. Now, I'm not saying YNW Melly killed anybody, innocent until proven guilty, whatever, blah, blah, blah. I don't know what the hell that is. But anyways, so you have that part. But you also had a part of, did he help set it up? No matter what he does, it's going to be a loss. He was on bail, out on bond, if y'all will, and got hit with witness tampering. What exactly those details are, I have no idea. Maybe he thinks he could beat certain things or whatever the hell. But like I said, if I'm YNW Bortlen, I walk in with my freaking lawyer looking like that, I'm looking at the judge like, you know what I'm saying? Looking like Popeye the Sailor Man while I'm glancing at the freaking judge. Either way it goes, I don't think it ends well for him. But if that's all you have is those two officers, well, they already had basically qualified 3 of them, and then you got Moretti coming in, and I don't think to me, I don't know, maybe his lawyer is good, bro. Like, you can't always underestimate old school. You know what I'm saying? There are some lawyers who look like that are fire, like, look like his cousin, like Dr. House, and we already seen House, the TV show. So maybe, you know what I'm saying? Maybe you like that, but I don't know, bro. Moretti's such a, I don't want to cuss, but he's such an a-hole. You know what I'm saying? Like, we seen and heard from Detective Moretti before, and it wasn't good. So there's that part. But also, we're going to be fair, square, obvious, and honest. From what we've seen in the Melly case, basically, he got found guilty, but one person might have overturned 3. So if I'm seeing that, and I know he has to know that, because he got arrested after the freaking trial. I know he has to know that. I'm thinking to myself, man, I don't know. But you also run the risk of, dang, bro, if YNW Melly beats the case, and I'm sitting here for 16 years, some of y'all say like Florida does 65%. No, bro. Go learn your laws. Truth of sentencing got passed in 2024. Go do your laws. Like a buddy from New York say, do your Googles. They tell y'all, literally. So I'm not going to argue with nobody when I can see SB-143 or whatever the hell it was. Like, I'm not arguing with y'all. If you can't recite the law while y'all put it there, don't use words. Just say, Seti Nash, you're wrong. Here's the law right here. Because I'm not going to argue you guys up and down. You're either going to get a yes or a no from me. That's it. But if I'm YNW Bortlen, bruh, I'm taking that deal. I am. I'm taking that deal. I'm going to have like one ask of people. Like, hey, bruh, just make sure I'm still here in Florida, not too far away from my family. That would be in my plea deal. Like, hey, all right, I want to do that, but bruh, make sure that I'm by my people. And it's gonna suck how this is gonna sound, but at least he gets a release date. At least he'll be able to come home 40 years old and still live a life, because I'm sorry. Based off of what we've seen in the Melly trial, bruh, it's just hard for me to believe you gonna walk away from this without an elbow. Y'all know what the elbow is? That's a straight up L. So that's my opinion, but y'all let me know y'all thoughts on this, man, because I'm not seeing it personally. I'm not seeing that man walking away. I'm just not. But maybe I'm wrong. And next time y'all see him, like, you know, the judge said, he gonna be in a suit, he gonna be suited and booted, I would ask the judge, like, hey, you think you can, you know what I'm saying, have somebody hit me up real quick? But who knows, bro? But I think, I'm sorry, I think he's gonna take it. I don't think we're gonna get no YNW Bortlen trial. I'm sorry. And if it looks like an admission of guilt, it's not. An admission of guilt is me saying, I did this and I'm willing to tell on this person. That's the admission of guilt, bro. I know some of y'all gonna be like, this hurts Melly's case. This hurts Melly's case. This hurts Melly's case. No, it doesn't. No, it doesn't. We watched the whole YSL trial, all them plea deals and all that stuff. Remember how everybody except for Thug and Duke said YSL is a gang? We got to the end. Nobody got convicted of YSL being a gang. So the lawyer can basically spin it like, man, we have corrupt detectives. We already had a lawyer thrown off. We have this, we have that. I would have signed the deal too if I was him. But Melly is innocent. That's what I would have did. Because Melly got Drew feeling though. And I ain't gonna hold you. I might have to go down there for this one. But hey, y'all, let me know your thoughts on this, man. Sure to keep your people aware, subscribe to that bell, stay notified. And I'll catch you in the next one. Make sure you are subscribed to the Reloaded page. And hey, you want to win one of these, just be a subscriber and comment on every video. From now on, once you become a subscriber, you gotta comment on every freaking video. That's part of it. Because when y'all comment on the videos, it helps push it to the algorithm. I know some of y'all like, I'm just here for Xbox. And y'all leave like 2 comments. I need y'all on every freaking video. I know that's asking a lot of you. Trust me, I know. If y'all do that, it's going to push the freaking algorithm. And by the time October gets here, we'll be at 300K. By the time we get to October, we hit 300K. By the time October 31st gets here, we're just going to double this up and give 4 away. 2 PlayStations and 2 Xboxes. But I'm click right here and see how Young Thug must have bumped his head on Georgian culture with Andre 3000. Because if it ain't no 3 stacks, it wouldn't be a Young Thug. The boy is disrespectful. Man, I'll catch y'all on the next one. Click right here, though.